Now we go.
Is this working? Madam Chair, thanks so much for inviting me here. I'm really, first of all, just privileged to sit next to not only the gem, but a giant in the world of demography, and I would be willing to give all my 15 minutes to him compared to what I have to say to his knowledge in this field. I think is extraordinary. It's my first actually foray into Prince William County, so I'm not sure how much of an expert in the county I am, but I've been looking at the process of devolution, as we call it, from federal to state and localities in the role of immigration enforcement over the last few years. And we at the Migration Policy Institute released this report yesterday, which is basically a legal analysis of the framework with which one must assess the legality of some of the most popular measures adopted by states and localities in the area of immigration. Glad to submit it to you for your review. I think we all know historically immigration has been seen as the exclusive domain of federal government. It's akin to foreign policy, that we can't have states and localities make foreign policy, that it must be consistent, coherent policy which must be dictated at the federal level. It's also true that, that our jurisprudence has recognized that states and localities have some role to play in immigration matters. It's also clear that it's highly circumscribed. And some of it is written into our jurisprudence and the laws of federalism. Some of it is governed straight by the way Congress has circumscribed the authority. And some have evolved in terms of the interpretation of individual rights as the courts have interpreted them over the years. We, in this study, look at 5 major areas, which is the regulation of employment by states and localities, the regulation of housing of undocumented by states and localities, the enforcement of immigration law by states and localities, the restrictions on public benefits adopted by states and localities, and the restrictions on day laborers to seek employment at street corners or at parking lots. These are the 5 major areas where we have seen recent trends in devolution. I think here today, just because given what Prince William County's resolution is focused on, I will talk about 2 measures, about law on this area has evolved and what it may mean in terms of the implementation of it in this county, which will be in the areas of the enforcement of immigration law and the restrictions on the access to certain public benefits. First of all, I mean, lawyers hate to agree on anything, but there are at least 2 areas of these 5 that I identified, which is the law enforcement and in the solicitation of ordinances, that one is safe to say that in this area law is quite settled compared to other areas where it is still contested. On the issue of the enforcement of immigration law by states and localities, there are 3 basic trends all over the country. There are trends where there are agreements signed by the federal government and the local or the state police to allow local and state police to enforce immigration law. That's one trend. The second trend is allowing, which is consistent with what Prince William County has done, is allowing people, local cops, to inquire into the immigration status of people they detain and then inform the federal authorities about people they find in violation of status. And there's a third trend, equally important, where localities and states tell their cops not to interfere in the enforcement of immigration law, which is somewhat called sanctuary cities in our popular parlance. All these 3 tendencies we see in the national debate today. Now, how does the legal analysis on this operate? First, I think only Attorney General Ashcroft today believes that local and state police have inherent authority to enforce immigration law. There were 3 attorney generals prior to him in Republican and Democratic administrations who came exactly to the opposite view, that given our structure of federalism, local and state cops do not have inherent authority to enforce immigration law. In a legal opinion that his administration issued in 2002, they concluded that they have inherent authority. I think most legal scholars disagree with that, especially given the 3 prior opinions of attorney generals stacked against that. No court has resolved that issue. It hasn't come to fruition before any court. But keep that sort of constitutional confusion aside. It's clear that Congress has spoken about it in reasonably specific terms, that there are two areas of federal immigration enforcement. There's civil immigration and there's criminal immigration. In civil immigration enforcement, Congress in 1996, in a major immigration reform law, basically said that if state and local cops want to enforce civil immigration law, they must sign memorandums of agreement with the federal government, under which you are specifically trained and supervised by the federal government so that you could then have some role in enforcement of civil immigration violations. That's what we call the Section 287G agreements. Popularly, this is a section of the Immigration Nationality Act. With respect to the criminal violations of immigration, a lot of people, I think there's general perception that there is unlimited authority for local cops to enforce criminal aspects of immigration law. Actually, if you look at congressional history on this, it's actually very specific and very narrow. Congress has said that there are only two areas in which local and state cops can enforce federal aspects of immigration law, which is 274 of the Immigration Act, which refers to harboring and transporting of illegal aliens, and Section 276 of the Immigration Act, which says that it's a felony for people to re-enter the country after they have been sent abroad after deportation. If they seek a re-entry, then they have committed a crime. Only in these two areas of law do the state and local cops have authority to enforce immigration law. So it's short of these three areas that I talked about. I think the Congress has been quite specific that this is a limited authority. And that's why I think most of the state laws that you've seen in this area are written narrowly in the confines of Section 287G. Now, there's a second area which is more relevant to Prince William County, is what authority does police have in ancillary to their normal police function? And this is where some of the controversy rests. I think it's quite clear under law that local police can ask anyone that they detain in their normal police function, if they arrest someone for a crime, that after they arrest someone for a crime, they can ask the person for their immigration status. I think in many jurisdictions that's considered a normal practice. What's important that you cannot arrest someone only on the basis of a suspicion that that person is undocumented. The underlying reason to detain that person must be a state or a local crime. And if you detain that person for a state or local crime and you ask them about their immigration, you cannot prolong the detention beyond what you would be normally authorized to do in the context of the underlying crime. So these are two very specific, I think, restrictions with respect to the ancillary extension of the immigration questioning. That first it must be ancillary to underlying arrest for a criminal, and then the detention must not prolong that you would normally do for the underlying crime.